Forget the Battle of Blackwater. Forget the Battle of King's Landing. You know what? Forget all those battles, because the battle between Sophie Turner and Joe Jonas for custody of their children is going to put them all to shame.
But Josh, how do you know? You've never even watched Game of Thrones.
True, but I know this because those were fake battles on a TV show, and this petition right here is very, very real. And you are about to find out how real it is, because we are going to break it down together. You're going to want to lawyer up for this one. Subscribe to the channel. Let's start from the beginning. After 4 years of marriage, Joe Jonas filed for divorce on September 1st, citing that his marriage with Sophie Turner was irretrievably broken. The couple put out a statement stating that the breakup was a joint, amicable decision, although a lawsuit stating international child abduction kind of puts a dent in that otherwise careful statement that's meant to use the media to manipulate the public's perception of what is really going on. This lawsuit claims that months ago, Turner and Jonas agreed to have the children accompany Jonas on tour while Turner was filming a show in various locations in the United Kingdom, which is not in America. Both parties agreed that in September, when Turner wrapped up filming, she would pick up the couple's children and return them to England, which I don't think that's in America either. However, when she arrived in New York just to do that, Joe Jonas refused to hand over the children's passports to send them with her to their home, which led to the filing of this petition for return of children to merry old England. The lawsuit was brought based on the Hague Convention, also known as the Convention on the Civil Aspects of International Child Abduction and the International Child Abduction Remedies Act. The Hague Convention essentially aims to secure the immediate return of children wrongfully removed or wrongfully retained. Filing a case under the convention does not guarantee that your child will be returned to you. You must first be able to demonstrate these things: that your child was habitually a resident in one convention country and was wrongfully removed or retained in another convention country, that the removal or retention of your child was in violation of your custodial rights, and you were exercising those rights at the time of the removal or retention, or you would have been exercising them but for the removal or retention. The convention must have been enforced between the two countries when the wrongful removal or retention occurred. The child also must be under the age of 16. And this brings us to the alleged violations of the Hague Convention here. First up is wrongful retention. As the lawsuit states, the Hague Convention applies to cases in which a child under the age of 16 years has been removed or retained from his or her habitual residence in breach of the rights of custody under the law of the children's habitual residence, which the petitioner had been exercising at the time of the wrongful removal or wrongful retention of the child, or in this case, children. The ex-couple's children are around 1 year old and 3 years old, and Turner's lawsuit attempts to prove that the children's habitual residence was England through a lengthy detailing of the several places that the family has lived in the past year, despite Jonas claiming on his divorce filing in court that the children's residence was Florida. That's in America. Although this seems like a fairly straightforward factual assertion, it can get complicated. Wealthy families really can have multiple residences. Now, these are not normal people problems, but also people with money can sometimes, and they will sometimes, pay lawyers many thousands of dollars to make it seem like their version of the facts is real, when it just isn't. And each judge is going to key off of different facts, such as where's the main pediatrician, or are there any school enrollments? What are they doing for extracurriculars? The second claim is less of an accusation and more of an invocation of Article 18 of the convention. This is pretty straightforward. Claim 1 says that England is the home country. They need a judge to agree with that. And the second claim is that they had a deal to send the kids back home to England, and Joe Jonas
is in breach.
How does this situation get resolved? Absent an agreement, there has to be an evidentiary hearing. It's not really a trial, but it's not a trial either. It's limited. It's just over these threshold issues raised in the petition: establishing the home country and asking for an order returning the children. This is just the type of case in which most judges are going to lean very, very heavily on the written, aka electronic, evidence of the existence of an informal agreement to return the kids earlier this month. Think about it this way. If Miss Turner can't produce texts or emails or other electronic documentation or messages that the children were by agreement going to be returned to England, then the lawsuit just appears to be full of lies. But if she can produce that communication, then it looks like Mr. Jonas is going back on his word. And I will tell you, judges don't like either of those things. So this case, if they have a contested hearing, it's going to turn on the clarity of the written agreement. Full stop. Now, of course, we know that Sophie Turner and Joe Jonas have called a temporary ceasefire and filed an interim consent order that states that both parties agree to keep their children in the eastern and southern districts of New York for the time being. Now, those are both in the U.S. They can't even think about stepping foot into the northern district, though. That crosses a line? Literally. The consent order is just a temporary agreement, and it seeks to relieve some of the tension between the parents for the short term, but it's not forever. And they will either find a way to reach a permanent agreement, or they will gear up for a depressing battle over their small children. I gotta tell you, judges just love consent orders. I mean, imagine, if you will, that a judge's job is to try to figure out what is the best thing to do for kids. And then you have these feuding parents who somehow agree on some aspect of what should happen. Unless that agreement is just inane, then the judge is not going to be able to sign that consent order fast enough. Give me the pen, I'm ready to sign. Custody fights are the scourge of many court dockets. Adversarial, formal proceedings that are used to decide guilt and innocence in criminal cases and money damages in civil cases are a tough way for broken families to seek solutions to disputes that they're having and to mend. Frankly, this custody battle is likely far from over. We'll likely be seeing a few more headlines about this breakup in the future, which I will be more than willing to break down for you, my amazing audience, but you gotta let me know that you want that breakdown by hitting the like button, believe me, it's down there, and the subscribe button, little used, but it is there also. And there was something else. What was it? Oh! Holy cow, of course, I want you to drop your pro se opinion down below with the news of this divorce. Are you team Sophie? Are you team Jonas? What do you think about Jonas's alleged refusal to let his children go back to England? And what do you think of my sick new office right here? Let me know your thoughts down below, and I will see you very soon because I'm right here. Bye.